welcoming everyone to the parallel session 1, New Challenges for Consumer Law. We've got 2 speakers in this session, and the first speaker is Jeannie Marie Patterson from the University of Melbourne. Jeannie is a co-director of the Centre for AI and Digital Ethics at Melbourne Law School and a professor of law at the law school. Her research focuses on themes of support for vulnerable consumers, the regulation of new technologies in consumer and financial markets, and regulatory design for protecting consumer rights and promoting safe, fair, and accountable technologies. Jeannie, I'm looking forward to your presentation now. You're still on mute?
Yeah, I'm off now. Can you hear me okay? Great. So I'm just going to share my screen.
Thank you.
I hope I'm going to share my screen because I think it's going to tell me that I'm blocked. Oh, there we go. Good. Hang on one sec. Sorry, I've got this security thing happening now, so give me a minute. I am going to talk about common law rather than common law regimes rather than the EU AI Act. So I think that's probably a nice comparison from the last session. Make my way through in a minute. Yay! There we go. It worked.
Thank you.
Took a moment. Okay. So I'm going to talk about fakes and AI and adapting consumer protection to the challenges of AI with a particular lens to generative AI, which seems to be sort of the movement of the moment and causing concern about whether existing law can adapt. And as we know, lots of forms of digital technology, AI, automation have hit the headlines at different times in their uses by governments and also private firms and social media. And the technologies are also increasingly used in providing services to consumers through various apps and increasingly sophisticated chatbot type technology. And while there are many uses of information of AI in the consumer space, one of the uses is actually as an information intermediary. So that's actually finding information for consumers that it would be hard for them to find, process, or use on their own. So the sort of simple forms were virtual assistants like Alexa or the chatbots that we get on various service provider sites, recommender systems, and now, of course, consumers, just like businesses, are starting to use ChatGPT to find and synthesize information for them as well as present that information on their behalf. And the common feature of these information intermediaries is providing efficient, consistent, accurate output for or to consumers. But the representations and the expectations around this technology are often overrated. And in fact, the information that's provided is often wrong or misleading, and even deceptive, and the data collection practices of these technologies are underplayed. So as the theme of the conference recognises, there's a current debate about whether existing law can be sufficient to respond to these technologies or whether we need some sort of specific law directed at AI. Now, in the jurisdiction I'm in, it's quite unlikely that we will get an AI Act or an AI Liability Act or even a review of our product liability regime. So we are kind of stuck with our existing legal regime. And the question is whether that's fit for purpose or whether we need tweaks to it. And that's what I'm going to look at briefly today. So, you know, I've made my point that AI is used in lots of different ways. And in fact, it's become a bit of a marketing term. So we're constantly being told, oh, you know, AI this and AI this, that, and it will help consumers. And I think that at one point was an attraction of this technology, and now we're starting to get a bit worried about it. Though I'd have to say, I won't even say make a comment about Elon Musk. We're starting to get a bit worried about it. Now, just honing ourselves down to information intermediaries, so that's the uses of AI to provide information for or about or with consumers, one of the concerns, not the only concern, there's of course bias and a lack of robustness and so on, but one of the concerns about information intermediaries, whether it's ChatGPT or something else, is simply that they'll fake it. So they may provide wrong, partial information, which is presented as accurate and flawless. So that's fake accuracy. The technology may pretend to be superhuman when it's not. That's fake AI. And it may pretend to be human, and that's AI fakes. And so those are the three things I'm going to talk about today to explore that question about whether we can respond to these concerns from existing legal doctrines and perhaps where we need complements, particularly in the form of soft law. So let's start with fake accuracy, and that's been a problem for a while with AI technology or information intermediaries, perhaps exaggerated with ChatGPT simply because the output looks so plausible that often it comes as a surprise to find it's quite simply made up. And the simple reason for that, it's kind of a pattern matching technology, doesn't have understanding, doesn't have insight. So if the pattern matches, we might get good output or we might get foolish output. The second concept of fakeness in technology is fake AI. So this is where the AI is pretending to be superhuman, and actually overlaps with that issue of fake accuracy, because the more we think the technology has capacities that doesn't, I suspect the less likely consumers or individuals are to provide a critical lens to it. And we see this concept of fake AI in a lot of consumer products. Robo and vacuum cleaners are supposed to have AI. Well, they use sensors. We're supposed to trade stocks using AI, where in fact they're using financial mathematics. We're supposed to rely on AI and apps that provide mental health care or health diagnosis. They're probably using simple expert systems, if that at all. So simple automated processes aren't in fact drawing on, the capacities enabled by data science or machine learning. What they are often is just smart interface up the front with something quite simpler behind. Now, this problem, the fake AI problem, the flip side of that is the AI fakes problem, and that's where we have AI pretending to be human. And to my mind, actually, the AI fake problem is actually the scariest one, because we can probably respond we probably know how to respond to the other two issues, inaccurate information or the overselling of the capacities of an AI-informed product. But when we get to AI fakes, that's AI pretending to be human, I think we start to get into quite uncharted and problematic territory. Now, it may have quite mundane effect. It may be a chatbot pretending to be a human in order to sell us something. But of course, the sort of nightmare scenarios can get worse when we have sort of dating scams and finance investment scams propagated through fake AI. And indeed the manipulation of the political and democratic process, which is something we talked a bit about in the last session. So those three types of AI fakes, which are fake accuracy, fake AI, and AI fakes pretending to be a human. Now, in fact, we have a law on fakes. While the technology has presented fakes in a new light, the fakes have been around in private law for a long time. We have a sophisticated law on misrepresentation, misleading conduct, deceit, and I should have added up there mistake, because of course there's all those cases in the common law and the general law on mistaken identity for people pretending to be someone they're not. So if we're just looking at private law as opposed to criminal law, we have a suite of legal doctrines that respond to fakes and respond to fakes in quite a sophisticated way. Now, with the rise of new technology, it's sometimes suggested that these existing areas of law are dinosaurs, that they're just not capable of dealing with the demands placed by new technology, which, is fast and large and opaque. And I think that's an element in that. I'd like to see more emphasis placed on, AI ethical standards of particularly transparency and explanation. But I'd also make the point that all of these rules are quite open textured. They're not specifically, they're not bright line rules in the way we see with, say, the AI Act. And that actually makes them quite flexible. It makes them able to respond to new manifestations of conduct that we've actually seen in the market for a long time, which is trying to trick people. Now, the FTC, which is the Federal Trade Commission in the US, kind of agrees, I think. I mean, I know that the US is using a combination of soft law standards and actually quite robust statements by their regulator about what should be done with the problem of fakes. And the regulator is quite adamant that, keep your AI claims in check, otherwise you will face regulatory action, and also making statements about issues of AI, the responsibilities of, sorry, I skipped a slide. The FTC has also been making statements about the responsibilities of developers of technology that can be used to fake humans. So the US FTC seems to be interested in exploring this capacity of existing law to respond to AI fakes, fake AI. Now, can that apply to generative AI, such as ChatGPT? We've seen a lot of concern that because these technologies are generative, as opposed to sort of relying on fixed or pre-programmed rules or simply built from models which are then applied according to particular rules, that it's harder to regulate them. And in fact, that those who are making this technology available may not be aware when errors occur because they don't have vision or foresight over what may come out of the mouth of those technologies. But in fact, that's hardly to the point in this field, because liability for fakes or deceit is often strict. It doesn't look at whether the problem was foreseeable or intentional or even negligent. It's you were responsible for conduct that misled or tricked or deceived people, and the liability sits there. Even where the liability is linked to some standard of negligence, so for example, in the tort of misrepresentation or under some statutory liability regimes, the problem is foreseeable. The problem of fakes is foreseeable with this technology. So again, would seem to place some responsibility in those who are making it available to take precautions to protect users. I mean, the hallucination problem, as it's commonly called in relation to ChatGPT creating content, is well known. So it would seem that even if we don't apply a strict liability regime, if we're looking for fault, then it's possible to land fault in those who make the technology available without taking precautions over those errors. Now, of course, in contract law, the most common form of precaution is not to put guardrails around the technology, but to provide a disclaimer. So this example on the screens now this is what happens, at least this was what happened a couple of weeks ago. If you ask Bing for legal advice, it gave you a disclaimer, a legal disclaimer. I'm not a lawyer, I can't give legal advice. We'll note it did go on then to give legal advice, it's just that it put a disclaimer up the front. Is this enough to absolve the provider of the technology for responsibility? It probably depends, actually, because while disclaimers are effective often in contractual relationships, they're not necessarily effective in consumer contexts, because as we know, if you have a consumer protection regime applying, so if it's the provision of services to a consumer, often consumer protection law is going to preclude disclaimers by either saying they're not effective in the light of otherwise misleading conduct, or simply say they're void. So the disclaimer point may not, in fact, be the answer to the problem. And it may be that that in direct-to-consumer provision of some of these services based on LLMs or GPT, that some sort of guardrails are going to have to put on the accuracy of the system. Now, of course, with the business-to-business application of that technology, the situation may be different, and we may see businesses trying to shift liability down the supply chain, though I think the AI Act may have something to say about that as well in Europe. In any event, the situation, I think, is that consumer law has a lot to say about inaccuracies in technology and indeed the representations about superhuman capacities of these technologies. Let's flip now to that that third form of AI fake, is where the AI is not pretending to be superhuman but giving inaccurate information, but where the AI is pretending to be a human and trying to gain some sort of advantage in that way. This is sort of the deep fake scam problem. Now, in Australia, we've got a case at the moment that is delving into quite this issue, which is, what do we do with the bad actor deep fake? And we may feel powerless against these sorts of assaults because, of course, the bad actor that perpetuated the scam will have disappeared. Interestingly, in Australia at the moment, the ACCC, our regulator, is exploring the possibility of accessorial liability for the platform that facilitated the showing of the deepfake. Now, we know there's various protections around platforms and the information they show on them. Typically, platforms aren't responsible for the material that they're showing. They're mere conduits of the information and therefore often protected. But, that changes where they're aware that there is a fraud being perpetuated through the platform they provide. And I think, you can pick that up through statutory accessorial rules or through general law rules. But I think it's going to be an interesting space to watch, where we see more scams making use of deepfake technology or generative AI, the capacity to create image or voice that looks realistic. We may well see more of these actions trying to hold the platform to account because it failed to act in response to known frauds. Of course, as has been made clear in the last session, legal liability is not the whole answer to the problem. And it's not the whole answer to the problem because suing someone after something has gone wrong is the sort of second best response. I mean, liability rules can provide an incentive to the market for better care, but at the end of the day, they're a bit of a crude assistance for consumers who may have been harmed, would like to stop the problem happening in the first place. I think the risk of liability sharpens the attention of the providers of the technology, but that also needs to be accompanied by the sort of soft law standards that some of the speakers in the last session were talking about. Now, transparency is key. Obviously, if a bot is interacting with a human, should disclose itself as such. That doesn't necessarily prevent the problem with the fraudster that is going to use the bot to perpetuate a scam. But I think there are suggestions currently of design standards that would make it easier to identify fakes and perhaps help with educating the general population about the need to be very careful what they do online. I mean, I'd have to agree with the last session. I think that there's lots of potential in soft law standards. What I'm a bit more sceptical about is writing these soft law standards into law, because once they're law, they become quite rigid and hard to change, and then the technology moves on and we're sort of stuck. So my answer to the question I started with, which is, can the general law deal with fake AI and AI fakes? I think it can, but it would like a little bit of assistance from some soft law standards. So that's me. Thanks, Norman.
Thank you very much, Jeannie. Great how you cut through the basically the morass and give us some direction and also some ideas on how regulation, what current laws can do, and where perhaps some additional regulation is needed. I asked our audience to put questions into the chat, but the chat was disabled for a while. I think we've found the problem, and it should be possible to send messages again. So please, if you tried before, please try again. It should be working now. Okay, thank you very much to Jeannie, and hopefully we can carry on the discussion in the Q&A. I move on to our next speaker, and our next speaker is Mateusz Koszowski, who is a senior research fellow at the Max Planck Institute for Comparative and International Private Law in Hamburg, and an affiliated fellow at the Information Society Project at Yale Law School. Mateusz works on the intersection of private law and new technology, especially on the platform economy, algorithmic price personalization, and regulation of the online consumer economy. Mateusz, the floor is yours.
Yes, thank you. Thank you so much, Norman. I hope you can hear me. I hope you can see my slides. So if everything on the technical side works well, I'm happy to start. And first of all, let me express again how grateful I am for being able to be here, speaking from my office in Hamburg, but speaking to the audience worldwide. Especially to my Asian colleagues who are based in Hong Kong and elsewhere in that region of the world. And I'm double happy because what I'm going to talk about today is partly rooted in the European experience of consumer law, but has a very broad and very intense, I would say, global or transnational ramifications. Because I'm going to talk about consumer law or consumer protection, which is emerging somehow in parallel or beyond the state-made consumer law or state-made regulatory attempts on the consumer market. Namely, I'm going to very briefly address the question of consumer rules or consumer protection measures that are developed by the online platforms such as Amazon, Uber, eBay, and so far. So the platforms we all know, the platforms we all use or were using in the past, and the platforms which I think right now are, as we all know probably, and especially for this audience, I do not need to probably explain it even further, the platforms that are to a great extent the de facto regulators of many parts of the social and economic life nowadays. So to begin with, as you probably know, or as you can easily imagine, the platform economy is based or has been traditionally based on this like foundational triangle structure where the platform is engaging itself in the vertical relations with all the platform users. So everyone who opens an account on Amazon, on eBay, on Twitter, and so far, creates an account and therefore makes a contract with the platform. But also platforms are massively regulating the horizontal agreements, so the horizontal liaisons between the platform users. So all the acts concerning contracting, concerning exchange of goods, services on other basis, concerning flows of information, flows of content between the platform users are directly regulated by platforms, which through many means, through many sometimes very compound internal regulatory architectures, are regulating those horizontal individual to individual relations. And when we look into those architectures, when we look into how platforms are regulating the communities of users, we can very easily come across multiple rules that can be qualified as consumer rules or consumer standards per se. And now just a few very, let's say, exemplary instances of this phenomenon, just to give you a brief overview of how it works. So, for example, many platforms are developing internal policies regarding return of goods, regarding warranties for defects of goods or services that are being purchased over the platform. Many platforms are developing some internal standards or internal tools, sometimes based on algorithms, based on AI, for detecting false reviews or for detecting instances of discrimination or of some racial profiling practices on the side of the suppliers of certain goods and services. For example, a couple of years ago, there was a pretty well-known scandal in the US regarding the racial discrimination on the ride-sharing platforms like Uber and Lyft. And those platforms, in response, very quickly introduced internal policies and internal review mechanisms for the racial profiling or racial discrimination practices amongst their users. So we can again multiply those examples, but in general, like the bottom line is that many platforms are pretty much involved in developing internal rules that aim to protect individuals, in particular the individuals who are considered to be the weaker or somehow disprivileged party to the particular horizontal relation. So the relation between the supplier of certain content, of certain goods and services, and the recipient of those goods, the buyer, the consumer, the client in general. And now, in order to further instantiate what I said, just again a few selected examples from the actual terms of service of online platforms. So, for example, on Amazon, as you can see, we can identify a number of provisions concerning the buyer's rights regarding the return of goods. And Amazon right now has a 14 days return policy. Probably all of you or most of you, including myself, has already made use of this policy. So we are all quite familiar with this. And why is it important for our topic? Because as you all know, in most of the on most of the domestic consumer markets, there are return or withdrawal rules based on the very same pattern. Very often rules which also adopt a 14-day or 21-day return policy or a 7-day return policy or whatsoever, which are very directly aimed at protecting buyers who may, after some time, after making a contract, regret the decision, may have some second thoughts, may want to reverse the contract they have already made. And in some jurisdictions, this is particularly characteristic for the European Union, there are some statutory rights regarding the consumer right to withdraw from the transaction within the period of, normally it's 14 days after the contract has been concluded. With the same underlying logic, so that consumers should have some time to cool off, to have some second thoughts, to be able to reconsider the transaction they have made, especially if the transaction was made online. In a moment, I will return to this example to speculate a little bit to what extent it can be put under the same rubric. So to what extent we can think of this Amazon policy as the example of thinking about consumer decision-making processes or consumer possibility to undo some contracts that have been made online. In fact, but in a moment. But now just a few more very, very sketchy, very brief examples. So on Amazon, there are also some other more specific rules on the return of goods purchased. Apart from this, there is a 30-day guarantee provided for consumers by Amazon, which, as you can see, applies only to the customers, to consumers within the EU. It's a separate topic why it has been limited only to the EU consumers, but in general, this provision provides the EU consumers with a broader scope of protection than the statutory warranty that has been awarded to EU consumers under the European Consumer Protection Law. Similarly, under the eBay user agreement, there are many rules concerning return policy, which in the case of eBay was based on the scheme we are are very much familiar with from the statutory law, which is a default rule scheme. So there is a default return policy set by eBay, which can be replaced by providers of goods, by sellers of goods with their own return policies created in this granular way for the particular transactions or for the particular online stores. Finally, consumers are also awarded with the specific claim procedure where they can make requests, where they can complain about the quality of goods and services, and there are also some rules introduced internally by eBay regarding how those claims, how those complaints should be processed, what are the deadlines for the sellers, and so far and so on. What is also important for the online platforms is the question of enforcement, because in many situations, apart from setting rules, platforms are also very powerful enforcers. Because first of all, platforms have normally the most direct access to the horizontal transaction between the seller and the buyer, which means that platforms are better suited to, for example, impose certain remedies, impose certain penalties, sanctions, for example, on the seller who does not comply with the return policy, than the any state regulator or any state court could be. Secondly, as you also probably know very well, platforms are doing a lot in order to isolate themselves from any direct intervention from the state-made law. So there are many pretty well-developed ODR or ADR schemes functioning on the online platforms. Many of those schemes are based on some automated or partly automated procedures which guarantee consumers that the reply will come quickly, the reply will come at no cost or at very little cost, comparing to the expense of time, expense of money, expense of effort they would have to make if they wanted to go with the particular consumer complaint to the court, which further enhances the position of online platforms as enforcers of consumer protection standards. However, in some situations, platforms do have to rely on some state-created, state-based enforcement mechanisms because they need to, for example, enforce certain penalties before state courts, or in turn, those penalties are checked or reviewed by state courts. For example, in the case when somebody is deplatformized, when somebody's account is suspended or deleted by a platform, then in many situations, such sanctions imposed by platforms upon users are reviewed, are checked for by courts. And both in Europe and in many other jurisdictions, we have multiple examples of litigations concerning removal of accounts from shopping platforms or from social media platforms, and probably you are quite familiar with them as well. And this all leads us to the question of something I framed here as the private altruism puzzle. So why platforms are engaging themselves in this kind of activity? And probably the most, let's say, grounding or the most simple answer to this question is pretty clear to everyone, because platforms are interested in maximizing the volume of transactions concluded upon themselves. Platforms are interested in attracting more users who will make more transactions, who will involve themselves in searching for products, in purchasing products, in purchasing services, in leaving reviews on the platform, which means that users must be interested in accessing the particular platform. They must be interested in opening an account on platform X and not on platform Y. And in many parts of the platform industry right now, we have at least some degree of competition, even on the markets that are mostly monopolized. For example, when it comes to consumer sales, look at Amazon, or when it comes to ride sharing, look at Uber. There are sometimes local, sometimes more than local, like regional or global, sometimes competitors to those quasi monopolists. So platforms are interested in competing over users, are interested in developing their own regulatory frameworks in a way that would beat the competitors. And how the competitors could be beaten in this situation by making the consumers, by making the clients more trusting that the particular platform provides a safe contracting environment, and B, that this platform provides a higher degree of protection or higher degree of entitlements to buyers than another competitor on the market. And when we look into the public relations, into the promotion strategies of some of the platforms, they indeed put those rights, for example, the right of withdrawal, the statutory guarantees, and so far, the paramount features, or some of the most paramount features for their internal regulatory design, and present them to consumers, present them to clients as something that distinguishes those platforms from the other platforms on the market, and something that should encourage consumers to open accounts and to actively contract upon the particular platform. However, what also comes into play here, and the Uber discrimination scandal I mentioned before is probably a very good instantiation of this phenomenon, is a strive of platforms to preempt state regulation. So in some situations, those internal regulatory standards are used as ways to either address some issues upon which there is some kind of a public upheaval. So where platforms are not necessarily trusting that, for example, clients will not start flowing away from the platform, which has been, for example, a protagonist of a big scandal like the discrimination scandal, or like some scandals that hit Facebook or some other social media platforms. And secondly, or in connection, in fact, with the first logic, there is also the second logic. So many platforms are introducing internal rules in order to create a strong case for not being regulated directly by the state. And here, the Uber anti-discrimination policy is a very good example. When you look into social media sector, what happened on Facebook, for example, after those multiple scandals concerning the election in the US and some other parts of the world, concerning Cambridge Analytica, concerning the leak of internal analysis of the Meta corporation, which revealed several very deep, very upsetting malfunctions of the entire platform system of Meta, was that Mark Zuckerberg created the Facebook Oversight Board. So this kind of internal adjudicatory body, as he called it, the Supreme Court of Facebook, which was intended to somehow handle the creation of standards for protection of users, in order to somehow make it more clear to regulators, in particular regulators in the US, but also in Europe, that Facebook is actively trying to handle this situation, that Facebook is actively trying to handle this scandal. But the question is, and this is another layer of the entire problem, to what extent we can think of platforms which operate upon this purely market logic. So first of all, to maximize the volume of transactions. Secondly, to win over competitors. Thirdly, to preempt state regulation. as effective regulators, effective handlers of the problems that consumer law should handle indeed, such as protection of minorities, such as protection of vulnerable users to the market, and so forth. And those issues can be observed from a multiple of perspectives. So for sure, one layer we should take into consideration is the general contract theory. So we should look into how the power dynamics in the platform economy function, how the private regulation is created by online platforms, and so far. Secondly, there is the theory of market regulation. So to what extent private entities, such as online platforms, can become effective regulators of matters such as discrimination, such as protection of vulnerabilities on the market. And here we have multiple examples from outside of the platform world, some of them dating back to 19th century liberal US ideology, where the state was trying to cooperate with big tycoons, like for example, the steel or railway corporations, in order to address some socially sensitive issues. And thirdly, the platform economy scholarship. So in particular, the research, the accounts of platforms as private regulators, as private sovereigns, as quasi-states, so as the spheres on the market or in the social life, which are isolated, which create some silos, regulated, governed internally by the platform. And there is a lot of scholarship concerning this with regard, for example, to online platforms such as Facebook, such as Twitter, but also regarding marketplaces such as Amazon. And the other question, and now I'm a little bit sketchy with my remarks, because I just wanted to somehow pinpoint various issues that function in this sphere, and I will be very happy to hear your questions or to expand on this a little bit later, because my time is running out. So the question of the choice of law, because as you know, in the classical legal framework, one of the key questions for both consumer and business-to-business contracts is what law, what jurisdiction, what legal system we choose for our transaction. In the platform economy, this question is a little bit reversed, because we are not necessarily thinking about choosing German law over Chinese law or over English law, but we are more concerned with choosing the contract concluded under the rules of Amazon or concluded under the rules of eBay, vis-a-vis the other possible regulatory regimes or regulatory frameworks that function on the market. And the sale agreement that we conclude on Amazon can be governed by different rules de facto, because of course the same civil code would apply to them, but de facto the most immediate regulatory framework provided by the platform can be different for each of those sale agreements or service agreements that we conclude. The other question, which is more like a political economy question, less.
Sorry to interrupt.
Yes. It's just the penultimate slide. So just 3 more sentences, and I'm finishing.
Thank you.
Is the question of transplanting consumer protection, because what platforms are doing is taking ideas, for example, for warranty or for withdrawal rights or for some information duties towards consumers from certain jurisdictions where the consumer protection standards are higher, and moving them, transplanting them into the jurisdictions where those standards are lower. And finally, the question is what states can do about it. And here the responses are twofold. So states can either control, review those internal regulatory frameworks and can accept them to the extent that they meet some basic criteria of fairness, or for the common states, they can accept them as long as there is no, for example, unconscionability issue involved or misrepresentation issue. And secondly, states can treat platforms as co-regulators and for example, when you look into Digital Services Act or the AI regulation, the forthcoming one, the EU AI regulation, we can find many examples of this approach. But those questions are still open, and thank you so much for your attention. I'll be very happy to hear your questions, comments, reactions to the consumer protection rules created by platforms themselves. Thank you.
Thank you very much, Mateusz. You certainly, took us into the area of transformation of, the relationship that exists between parties here, and also the need for, basically new approaches to, crafting rules that work in the platform context. I have a few questions, and the first question that I would like to ask is for Jeannie. And, so basically, and it's actually also borne out by what Mateusz was talking about. So basically, platforms create rules and have terms and conditions by which they operate. But sometimes those rules are invalid, really, under consumer law. Sometimes they don't give you all the rights that you should have under basically state-made law. So, for example, in your, you gave the example of the disclaimers, that, the generative AI might have a disclaimer, but it doesn't actually, it's not really valid. What can we do to, to protect consumers in those circumstances? Because consumers may just read what's written there and say, well, maybe I can't do anything about it. What can the state really do to ensure that the rules as they're written in the platforms are actually basically in line with consumer protection laws? Jeannie? We can't hear you.
You are muted, I think.
Yeah, no, sorry, I was muted by the system.
Oh, okay.
But I've been unmuted by the system now. That's okay. So I think the question is, and it's a really good question because it's difference between the law in the books. These are the principles that providers of services and goods have to comply with, and the law in practice where consumers aren't necessarily aware of that. And I think, to be honest, I think that requires robust regulators. That question of how do we make sure that providers of, platform providers or providers of AI services comply with the rules, that's the job for the regulator, because that power imbalance that we talked about, that Mateusz talked about, sorry, I said your name wrong, Mateusz talked about, is the point. We shouldn't responsibilise consumers. That's the role for the regulator, really, to be robust in scrutinising those terms and taking action if need be. That's the sort of hard end, I think, where we need the regulator. And I'll just say one other thing, that the sort of internal dispute resolution programs that a lot of platform providers offer, actually they deal with the sort of contractual aspect of the relationship. They don't deal with the sort of the vitiated consent power imbalance side of the relationship. But, having good contractual rules actually clears the space so we can focus on those bigger problems.
Thank you. Mateusz, do you want to respond to that?
Yes. So I think I completely agree with what Jenny said, and I just maybe two more things to add to this. So for sure, there is a growing awareness, and this is why I mentioned co-regulation on my last slide, growing awareness also on the side of platforms that certain problems of the platform economy must be tackled in cooperation between platforms and the states. And I think we are still at the very beginning of this journey. And what European Union has been doing right now is more, to me, like an experiment, like proving the ground to what extent platforms might be interested in involving themselves in co-regulation, in creation some standards, also in creation some internal dispute resolution mechanisms. Because, for example, Digital Services Act is quite, I would say, generous in vesting platforms with the power of creating their own internal dispute resolution systems that would be let's say, that would get some like semi-recognition from the side of the EU or of the member states. So that's my first point. And secondly, I think there's also like a parallel process which is happening both in Europe but also in many other countries I am aware of, which are attempts to devise tools that would allow to review the internal regulatory architecture of platforms. And in Europe, it is relatively easier because there is the Unfair Contract Terms Directive, which provides an immediate tool for reviewing clauses in business to consumer contracts, and which has been quite successfully used to, for example, control particular clauses in Facebook user agreement or Amazon user agreement for their consumer fairness. But at the same time, also in the common law countries, there is some case law concerning unconscionability of clauses in a platform to consumer contracts. For example, in Canada, there were some litigations concerning unconscionability of clauses in the Uber user agreement. So I think this is also something we must keep in mind regarding this compliance of platforms with the consumer protection standards.
Thank you, Mateusz. Harvey, could you unmute Jeannie again? I can't do it, unfortunately.
Sorry, I'll stay unmuted.
No, there you are.
I was just going to make a comment on that, on the sort of ASEAN, Southeast Asia type side, where there are similarly, I think there is a variety of consumer protection rules that may or may not address these problems. But I think one interesting thing that comes from EU and also particularly the EU intervention is whether we'll see across all of the regions sort of a rise to the top, not the rise to the bottom. At one point, I went and looked at the terms in digital service contracts where there was unfair contract terms regimes and where there wasn't. And actually the platforms were slicing and dicing regions. So, you know, here are the nice rules for Europe, here are the less nice rules for other places. So I think that's an interesting ongoing conversation too.
Thank you. You know, we've got a few questions, but unfortunately, I think we will not be able to answer them or to pose them all. You know, so I've got a question from Christian Twig-Flessner, who was first. So I'll use this one. He asks Mateusz, isn't the private regulation dimension of online platforms just another instance of private rule setting and enforcement that has been around for a long time in so many sectors? Is there a difference between, say, a trade association enforcing obligations on members in a code of practice, including by adjudicating on consumer complaints, and online platforms? After all, such self-regulatory private initiatives are often preferred by governments as much as by business.
Oh, so thank you, Christian, for this question. But I think my answer would take like another pretty robust paper. But in a nutshell, of course you're right. So it is just another instance of private regulation of the market we've known for like decades, if not centuries. But there are some specific characteristics or specific peculiarities to what's happening in the platform industry. And apart from the most obvious things we may have in mind, such as the global dimension of the platform industry, the massive use of consumer data, which is also one of the grounds for regulation of the consumer communities gathered within or around platforms. It is also, there are also some very peculiar questions concerning, first of all, some sort of totality of regimes created by platform, because it's not only 19th century commercial chambers that were creating some rules for its members concerning how they should trade particular goods or services, the regimes created by platforms are at least trying to be like all embracing and exhaustive. So they are trying not only to create rules, but also to create some ways of enforcing those rules, some ways of supplementing those rules. Look, for example, at Facebook Oversight Board, how Facebook is trying to create some kind of like self-sufficient internal quasi-legal system in this way. Secondly, platforms are also, in terms of the scale, they are much more meaningful as regulators of consumer matters than any commercial chamber could be in the past. There is a number of studies concerning self-regulation in the free internet world. For example, Lisa Bernstein from Chicago Law School has been doing a lot of work on this. But and of course, many parts of this framework can be applied to platforms, but at the same time, I think we are facing many new challenges. And of course, a huge challenge, which we are still at the very verge of, is the use of AI as the regulatory tool, or as a part of those internal regulatory frameworks developed by platforms. So I know it's a very sketchy answer, but I think it is along the same line, but it is still quite peculiar in many regards.
Okay. Thank you again, Matthias. Thank you again, Jeannie.